Hello class, my name is John Creighton, and today with the help of my dry erase board, I'd like to explain the issue of patent assertion entities, or patent trolls. A troll is a mythical creature that lives in caves or under a bridge, and tries to trick and steal from humans. In the business world, a PAE does exactly that. Patent trolls produce no products and conduct little research to create new ideas. Instead, they buy patents from other companies and use them to make money by extorting companies that build a successful market for a product. Patent trolls routinely engage in the practice of sending demand letters to unsuspecting startups and small businesses in preparation for going after larger entities. These demand letters sent by PAEs require no information about which patent and how they are infringing on the patent. There is little reliable information that is freely accessible as to what a patent actually encompasses. PAEs offer a license agreement to the small business for the use of the patent, in return for upfront payments for past damages and royalties on future sales. Small businesses are prohibited from discussing their strategies in public by license terms offered by the PAEs. Most companies take the license in response without fully understanding what they are paying for, and once they agree to the license deal, they are posted on the PAE's website, making them easy targets for other patent trolls. So, a small business, such as like a hotel, uses Wi-Fi for internet access to each room. And a patent troll will send a demand letter saying that you're infringing upon their patent by using Wi-Fi. And in the demand letter, they offer a license agreement saying you can pay for prior royalties and pay a percentage of future sales. And if you agree to this, you're prohibited from discussing these strategies in public. So you can't talk to other hotels and ask them how they dealt with patent trolls. And once you agree to these, the agreement is posted on the website, of the patent troll website, so that other patent trolls can easily see this and go after you as well for other mindless patents. And the reason most companies agree to this is because litigation costs are a lot more expensive than just paying the troll, fee. Many small businesses have a significant operational impact, including change in business strategy, product change, reduction in value, and possible closure. Patent Progress has come up with common sense solutions to fix the patent troll problem, including changing the economics behind patent trolling, leveling the playing field, and bringing transparency to the system. By changing the economics behind patent trolling, trolls will not be allowed to use the crushing cost of litigation as a weapon. Shifting court and litigation fees to the loser and having plaintiffs posting a bond at the beginning of the case will reduce the amount of patent cases. Most business methods and software patents are vague, broad, and abstract. By using the same review process used by the Patent Product Office, fewer patents will come into fruition. Another major change behind the economics would be to eliminate Civil Form 18. Civil Form 18 dates back before World War II and is not apt to the modern patent litigation, including software and method claims. To file Civil Form 18, a lawyer does not need to specify which claims are being infringed upon, as well as features of the technology that correspond with the claim. Today, a PAE only needs to fill out Civil Form 18, not specify what patent is being infringed upon in order to sue a company. By eliminating this form, you allow defense to know what patents they are infringing upon. By leveling the playing field, legal fees and taxpayer dollars will not be used on litigating patents whose legitimacy is in question. The patent is in question is being reviewed by the Patent and Trademark Office. By not allowing it to go to litigation, will drastically reduce the financial burden put on small business owners to fight patent trolls. With a vast array of low-quality software and business method patents, Patent and Trademark Office, by increasing the standard which a patent is judged upon, the assumption of valid patents will decrease. By bringing transparency to the system, trolls will not be able to sue before proving they own a patent. As of today, lawsuits can be filed without any proof of patent ownership. In a copyright case, though, patents are required beforehand to prove that they own the property in question. It is unjust to require defendants to spend money just to determine if the plaintiff actually owns the patent. By making patents the same standard as copyright, expensive litigating costs and court resources could be used on more pressing items. To Defendants are also do not have to disclose who exactly are suing them. PEs do not have to disclose real parties in interest. Parties in interest can include business competitors, and defense should know everyone that has a financial interest in the outcome of litigation. The topic of patent assertion entities has reached Congress. In late March, the Innovation Act bill passed through the United States House of Representatives. Patent demand letters are still allowed, but information about the patent in question, what is being infringed upon, and how are now required. Only one amendment was passed, though, which takes out the rarely used provision in patent law, allows patent applicants who can't get their patents from the patent office to sue them in court. This topic affects the hospitality industry because many hotels and restaurants are small businesses. 93% have fewer than 50 employees. Patent trolls prey on small businesses and know they cannot afford litigation, so instead of fighting, they agree to pay a tax. Racketeer Influence and Corruption Organization Act, or RICO Act, defines a racket as a service that is fraudulently ordered to solve a problem, such as for a problem that does not exactly exist, will not be affected, or not otherwise exist. As with most issues in the United States, political agendas will ultimately decide whether or not something will be done to stop this detriment to society. Thank you.